All right, hey guys, I just did a live roadside chat from Kootenai County. I'm gonna do another one because I got a lot of these I want to kind of catch up. So this question comes from an officer in the Army, okay? And he says, does a cat out of the bag search apply to digital evidence too? I'm gonna explain to you what a cat out of the bag search is in a second here, but let me give you his background. He says, I was watching one of your videos called cat out of the bag searches. So hopefully, if you're interested in that video, search it on the YouTube channel. And I was wondering if it also applies to digital devices. In the Army, we sometimes have family members of the service members bring us digital evidence where they saw, let's say, child pornography on it. Can we use a cat out of the bag search to justify searching without first seeking a search warrant? All right, the answer is yes, but let me kind of go into what's going on here, okay? Number one, what the heck is a cat out of the bag search? This is something that we at Blue to Gold call private searches, okay? We call these private searches cat out of the bag searches. It comes from a court case called U.S. versus Jacobson, United States Supreme Court, 1984. Okay. What happened in Jacobson is that a FedEx employee searched Jacobson's parcel. They thought it got damaged. While in there, they saw cocaine. They called the DEA, they showed up, and the DEA opened the package again and searched it like FedEx did. Jacobson said this violated his Fourth Amendment rights because he had a privacy interest in the package. The U.S. Supreme Court said no, that no search occurred here because essentially, the way we teach it, the cat was out of the bag. The private search already relinquished the privacy interest. And as long as the police do not exceed the private search, then no search has occurred at all. Let's bring it to our digital devices. If a private person that is not the agent of government searches a digital device, let's say a USB drive, and finds child porn, and let's say that the person searching the digital device does not have common authority, meaning they have no right to let other people search it anyway. Let's say it's the girlfriend finds it on the boyfriend's hard drive and then takes that hard drive from the home, essentially steals it, and brings it to the police. The police then replicate the private search. Would that be permissible under the Fourth Amendment? The answer is yes, because the police are not exceeding the private search. Now, let's imagine that the girlfriend found the child porn on folder ABC. Police then look under the folder ABC, see the same thing. But they also see another folder called XYZ. And they open that up and they find evidence of credit card fraud. Would that evidence come in? The answer is likely no, because police cannot exceed the private search. See, the suspect, defendant, has not lost his privacy interest into things not searched by the private person. For those areas, the cop should go get a search warrant. Now, the final message here, okay? The answer is yes for my friend here, right? And the Army, federal rules versus this, the same rules for my cops under the Fourth Amendment. But just because you can doesn't mean you should. I'm okay from a legal point of view of using cat out of the bag searches for backpacks that have been searched by other people and so forth. But I'm not really good with this with digital devices. There's too much at stake. First of all, these are child pornography investigations. These result in potentially decades in prison. Digital devices have always caused a little heartburn with judges when cops search without a warrant because of the massive amount of data that digital devices can contain, especially like cell phones, right? So be careful with it. Now, let me give you one case example where I thought it was legitimate to search a digital device under cat out of the bag, under Jacobson. A Topeka officer got a call to a grocery store. A customer accidentally left his cell phone behind. The cashier then turned the phone on, like the screen, to see if there was any kind of identifying information. This guy put his child porn picture on the home screen. It's unbelievable, right? It's like these criminals want to get caught. Then, of course, seeing that, they turned off the phone because they don't want the phone to be remote wiped. The cop showed up, and the cop then turns the phone back on to see the picture, to kind of confirm what's kind of going on here. Is that a cat out of the bag search? The answer is yes, right? The answer is yes, because turning on the phone is viewed as a search under the Fourth Amendment. You are physically manipulating a phone to try to find information. That phone is not abandoned property, it is lost property. So lost property is protected by the Fourth Amendment. And so when the cop turned the phone on, that is a search. But it is a cat out of the bag search. The defendant here has no privacy interest in what is been seen by the private person. Now, if the officer exceeded that private search by going into the phone, looking at other pictures, that would violate Jacobson, and that evidence would be suppressed. Okay, we clear? All right, that's enough for today. All right, or not today, I might do another one later. But all right, thanks guys, keep them coming. If you have your question you want to ask, email me, go to bluetogold.com/show and give me your question too. All right, see you.